Welcome back to Congress Unpacked, where we break down the moments Washington hopes you'll forget. Let's dive into a tense Judiciary Committee exchange. Senator John Kennedy questioning judicial nominee Sara Hill. What started as a routine confirmation hearing quickly turned into a test of legal depth and composure, as Kennedy's trademark style turned every question into a spotlight moment. It was less a Q&A, and more like a 6-minute bar exam under pressure. Senator Kennedy started with what sounded like a simple ask, "Miss Hill, what is collateral estoppel?" But the simplicity was the trap. It's a classic Kennedy move, testing whether nominees really understand the fundamentals, not just the flashier parts of the law. The room freezes. Hill hesitates. Collateral estoppel. She stumbles, blaming the bright lights. Kennedy's quick. "So you don't recall it, okay?"
Ms. Hill, what is collateral estoppel?
Collateral estoppel. I think collateral estoppel. Well, Senator, I will say that my 20 years of practice has primarily been dealing with issues relating to criminal law or relating to other areas of the law.
Yes,
and
if you don't know, just tell me.
I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it. Okay.
That brief exchange set the tone for what came next. From that moment it was clear. This wasn't going to be a friendly Q&A. It was going to be a legal stress test, and Hill was on the hot seat. Kennedy isn't letting up. He asks, "What is the amount in controversy requirement? What does the 13th Amendment do?" Hill catches her breath, correctly saying the 13th bans slavery, and the 7th guarantees civil jury trials.
What is the amount in controversy requirement?
The amount in controversy requirement is $75,000. It typically governs, in many cases, almost any case in diversity jurisdiction in the federal courts.
Okay.
And in certain other.
What does the 13th Amendment to the Constitution do?
It outlaws slavery.
What does the 7th Amendment do?
It ensures that all civil jury trials, that all civil cases in the United States are done by jury trial. That you have a right to a jury trial in a civil case.
Small victories, but the pressure's mounting. Kennedy keeps digging deeper. What's the difference between a stay order and an injunction? Tell me about the multi-district litigation statute. Hill admits she's not familiar with MDL cases.
Okay. What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you the.
Okay.
That.
Tell me about, you'll see a lot of this in federal court, tell me about the multi-district litigation statute.
So I'm not extremely familiar with the multi-district litigation. I do know that multi-district litigation is often consolidated into a particular court. So all of the cases involving a particular type of issue, if there is a multi-district litigation, those will all be referred to one court and one judge who will then oversee the MDL. But I will confess I'm not super familiar with all the ins and outs of that.
Okay.
Kennedy's face, priceless. It's not just questioning, it's a test of courtroom readiness. Now before we continue, if you love these moments where Washington's polish meets real-world accountability, hit that subscribe button and stay with Congress Unpacked. Back to the hearing, Kennedy throws a curveball. What kind of constitutional claims are subject to intermediate judicial scrutiny? Hill cautiously answers, cases involving gender or illegitimacy. Kennedy nods but fires back. What's a 12b6 motion? Hill nails it. It's a motion to dismiss.
What kind of constitutional claims are subject to intermediate judicial scrutiny?
Cases involving certain types of classes, such as gender or illegitimacy, are subject to intermediate scrutiny. Some types of speech, like commercial speech, would be subject to intermediate scrutiny.
Okay. Tell me what a 12b6 motion is.
It's a motion to dismiss a claim, or a motion to dismiss an issue for failure to state a claim.
Okay. And what's the standard for granting a summary judgment in federal court?
It says there are no issues of material fact, and that the issue can therefore be decided as a matter of law.
Okay.
She's gaining ground, but Kennedy shifts to the Eighth Amendment. Things get philosophical. What's the standard for cruel and unusual punishment? Hill talks about evolving standards. Kennedy's not buying it. They spar over historical context versus modern interpretation.
What's the standard for deciding whether a particular punishment is cruel and unusual under the Eighth Amendment?
So the particular standard the court has said, and I cannot recall the case, but it says that you have to look at not only whether it is would be shocking to the individuals at the time that it was written, so it's not purely a historical review, as some of them are purely historical, but also you have to look at how it has changed, how those values have changed with time. It's one of those cases, circumstances where the court says it's appropriate to look at how values have changed with time.
Well, our right against cruel and unusual punishment is a fundamental right, is it not?
It is.
Okay. How do you square what you just told me about the Eighth Amendment with the case after case after case by the U.S. Supreme Court that says the definition of a fundamental right is one that's explicitly stated in the Constitution or deeply rooted in our history and tradition?
Yeah, I think that it is. I think it is deeply rooted in our history and tradition.
Yeah, but certain forms of punishment are not. If a form of punishment, it existed at the time of our founding, and it's deeply rooted in our history and tradition, you telling me that makes it automatically constitutional today? I thought you just told me.
No, I'm certainly not saying that. I'm not. What I say about it is really quite irrelevant, but the Supreme Court has said we look at it with a view to the changing values on these
why
issues.
The difference? I thought
they're
both fundamental rights. Why the difference?
You know, I think that's a question that the Supreme Court's going to have to answer, whether or not they have.
I think it has. I'm just asking if you know.
I think I've answered the question to the best of my ability, Senator.
Okay. Thank you all.
Senator Hawley going to return? No. I think that all the senators have appeared who are going to question today. Ms. Hill, I congratulate you on surviving the John Kennedy 6-minute bar exam.
My contracts teacher is going to be appalled, and I'm going to have to live with that, Senator, but thank you, Chair. Thank you.
If you promise to spare Ms. Hill, I'll...
Did the White House give any of you any written materials to use to prepare?
They gave...
Or digital materials?
They gave us, previous questions that had been asked by the panel.
And answers?
I think we had to go find the answers ourselves. I think we had to go watch the various committee
May I
meetings.
have a copy of that?
I don't have one, but I'm sure that it is literally just a list of questions.
I don't have a copy.
I don't have any copy.
Would you send me a copy? I'm easy to find. Would you send me a copy, Ms. Hill?
I will.
Okay. Would you each send me a copy?
Yes,
so I can
Senator.
compare and make sure they're all the same. Okay. Thank you.
Senator, can we have a copy of your list of questions to share with
Sure.
other members?
I'll even give you the answer.
It's like a bar. It's like a bar review course.
Yes.
Senator Lee?
After breaks the tension. Even Hill smiles. Kennedy smirks. I'll give the answers next time. But beneath humor lies a serious question. How prepared are our judicial nominees for those lifetime appointments? If this breakdown's your kind of content, hit that like button, drop your thoughts in the comments, and don't forget to subscribe. Because here on Congress Unpacked, we don't just tell you what happened, we unpack why it matters, cutting through the politics, and getting straight to the truth behind every hearing.